What were the main sources of Roman inheritance law? Have you ever wondered how the Romans decided who got what after someone passed away? In ancient Rome, inheritance law was a big deal, and it was shaped by a few key sources. Let's break it down. The foundation of Roman inheritance law came from civil law, known as ius civile. This was particularly influenced by the 12 tables, which were established around 450 years before the Common Era. The 12 tables were the first written laws in Rome and included rules about inheritance. They set strict guidelines on how property was passed on after death, how debts were handled, and the rights of heirs. But the 12 tables were not the only source. There was also the law of the praetor, called ius honorarium. This law was more flexible and adapted to the changing needs of society. Praetors would issue edicts and make judicial decisions that could soften the rigid rules of the 12 tables. This meant that the law could evolve over time to better serve the people. Roman inheritance law was quite detailed and covered two main types of succession: intestate and testate. Intestate succession happened when someone died without a will, while testate succession involved a valid will. Interestingly, Roman law treated male and female children equally when it came to inheritance rights, which was not common in many other cultures. Most Romans preferred to make wills to avoid intestacy. These wills had to follow specific formalities to be considered valid. Typically, a will would name an heir and could also appoint guardians for any minors or freed slaves. The process of creating a will involved writing on 3 wooden tablets covered with wax. This method was designed to prevent tampering and was mandated by a law known as the Senatus Consultum Neronianum in the 1st century of the Common Era. Additionally, a system called fideicomissa, or trusts, emerged. This allowed for more flexibility in bequests, providing options beyond the strict rules of civil law. Another important aspect of Roman inheritance law was bonorum possessio. This was a Praetorian remedy that allowed individuals to possess an estate based on the will, against the will, or in cases of intestacy. This showcased the interaction between civil law and Praetorian law, allowing for a more balanced approach to inheritance issues. In summary, the main sources of Roman inheritance law were rooted in the 12 tables and civil law, enriched by the praetor's law. This combination created a system that ensured orderly succession and protected family property rights in ancient Rome.